Get ready for the dictation. Dictation will start in 5 seconds. Start. The present applicants apprehending their disposition in execution of the decree passed in favor of respondent number 1 submitted their objections before the executing court inter alia, submitting that the property in dispute was purchased by them much before the institution of the suit and as their vendor, and they themselves were not joined as party in the suit. The decree passed in favor of the decree holder was not executable against their interest. They prayed for an inquiry in accordance with the Order 21, Rules 98 and 101. The decree holder opposed the application tooth and nail and submitted before the court that as the present applicants or objectors had purchased the property during the pendency of the suit. Therefore, in view of the bar contained under section 52 of the Transfer of Property Act, the present petitioners or objectors have no rights in their favor. Their application was worth rejection. Learned counsel for the applicants submits that as the property was purchased by them much before the institution of the suit, therefore as their vendor and they themselves were not joined as parties to the suit, firstly, the decree was not binding upon them, and secondly, without making any inquiry in relation to the right, title or interest of the present objectors, the decree could not be executed. It is also contained that the court below was unjustified in observing that the property was purchased by the applicants during the pendency of the suit. A fair perusal of Rule 103 of Order 21 would show that where an application is adjudicated upon under Rule 98 or Rule 100 CPC, then the order passed on such application shall have the same force and shall be subject to the same conditions as to an appeal or otherwise as if the order of adjudication was in fact a decree. The very first requirement for attraction of Rule 103 is that an application must have been adjudicated upon. According to Rule 101, all questions, including the questions relating to right, title or interest in the property arising between the parties to a proceeding on an application under Rule 97 or Rule 99 relevant to the adjudication of the application shall be determined by the court dealing with the application and not by a separate suit. The questions referred to in Rule 101 are the questions which can be raised under Rule 97 or Rule 99. Rule 97 says that when resistance or obstruction to possession of immovable property is offered, then the decree holder may make an application to the court which is executing the decree, making a complaint that resistance was offered, therefore the said resistance be removed. When a decree holder complains of resistance to the execution of a decree, it is incumbent on the execution court to adjudicate upon it. But while making adjudication, the court is obliged to determine only such question as may be arising between the parties to a proceeding on such complaint, and that such questions must be relevant to the adjudication of the complaint. It is clear that the executing court can decide whether the register or obstructor is a person bound by the decree and he refuses to vacate the property that question also squarely falls within the adjudicatory process contemplated in Order 21 Rule 97(2) of the Code. The adjudication mentioned herein need not necessarily involve a detailed inquiry in collection of evidence. The court can make the adjudication on admitted facts or even on the averments made by the register. Of course, the court can direct the parties to adduce evidence for such determination if the court deems it necessary. Full stop.